Good morning. Thank you, Mr. Chairman, members of the board. Good morning to everyone out there. The Board of Liquor License Commissioners for Baltimore City proceedings will now begin. Please take this opportunity to turn off or mute all electronic devices. The board is now in session. Pardon me. Mr. Chairman, we have one preliminary matter before we begin.
Okay.
Case number 1 on the violation docket has been postponed and will be heard at a later date. For those on the record, that case is OK Tavern, 2301 East Biddle Street, which is a Class BD7 violation of Rule 4.20 little c 2 little I, violation of Rule 3.09A, and violation of Rule 3.09B. And without further ado, we'll move into the regular business. Starting out, we have 90-day transfer hardship extensions. Bmore Aeropass, 1616 Thames Street, Class D beer and light wine license, request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article 12-1705B. Please come forward.
Thank you. Good morning, Your Honor, Commissioners. Stephen W. Fogelman on behalf of the applicant here.
Mr. Fogelman, your letter says you want a 180-day hardship extension. She just said 90. Which is it?
Well, it is 180, and this is this was filed out of an abundance of caution. We have a prior licensee who we weren't sure was going to sign a transfer authorization affidavit of compliance to effectuate the transfer to Mr. Dams and Bmore Arepas. Meanwhile, that has been resolved now, but not until right after I had filed this request. However, Mr. Dams is also coming up on a fast approaching deadline to finish this transfer. So just in case that transfer was not completed in time, the landlord, Mr. Burkert, wanted that 180 days in order to make sure that the license remains viable.
Okay. Do we have a problem with that, Ms. Wurzburger?
No, sir.
Okay. Commissioners have questions?
No questions.
No questions.
All right. Thank you. Anything further, Ms. Fogelman?
No, thank you very much.
All right. All right. On the basis then of your request of March 27, 2024, and your proffer this morning, vote to approve a 180-day hardship transfer extension for this Class D beer and light wine license.
Yes, based on materials, letter, and testimony from the attorney, I also vote to approve the request for transfer hardship extension of 180 days.
Based on your March 27, 2024 letter, in your proffer today, I also vote to approve this transfer hardship extension of this Class D beer and light wine license for 180 days.
Ms. Russell?
No exhibits for the record.
All right. Thank you.
Thank
Ms.
you.
Fogelman.
Thank you.
Hideout Liquors, LLC, 2101 through 03 East North Avenue, Class BD7 beer, wine, and liquor license, request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article 12-1705B. Please come forward.
For the record, Melvin J. Kadensky, I'm pinch hitting for Mr. Abe Hurdle, who's in Thailand. Something about Interpol won't let him come back, but that's neither here nor there for his client. They just need more additional time to finish this, the transfer pursuing his request, and I think they'll have most of the information by the time he gets back here, if he ever gets out of the country there.
Okay. Commissioners have questions?
No questions.
No questions.
All right, thank you. On the basis of Mr. Hurdle's letter to the board from March 29, 2024, and Mr. Kadensky's proffer this morning, I vote to approve a 90-day transfer hardship extension for this BG7 license.
Yes, based on materials, letter, and testimony from the attorney, I also vote to approve the request for transfer hardship extension of 90 days.
Based on the March 29th letter and proffer made today, I also vote to approve this transfer hardship extension of this Class BD7 beer, wine, and liquor license for 90 days.
Ms. Russell?
No exhibits for the record.
All right, thank you.
Thank you.
Tutti Gusti, 3100 Fate Avenue, Class D beer, wine, and liquor license, request for a transfer hardship extension under the provisions of the Alcoholic Beverage and Cannabis Article 12-1705B. Please come forward.
Thank you. Good morning again, Your Honor, Commissioners. I represent Tutti Gusti at 3100 Fate Avenue. This is a case where basically all the Inspections were completed, everything was good to go for transfer, and then no one could find the transfer authorization affidavit of compliance and bill of sale. There's three things that the board certainly needs to transfer this license. Mr. Thapa, since then, has gotten in touch with the prior, or now current licensee. Those documents have been executed and will be delivered to the board in the next few days, and the transfer will be completed. And I think I filed this probably almost a month ago. It's been a while because of renewals. Yeah, so we just needed that little bit of extra time, and we thank you in advance for granting that.
Commissioners have questions?
No questions.
No questions.
All right, Mr. Fogelman, thank you. On the basis of your request of March 5, 2024, and your proffer this morning, I vote to approve a 90-day transfer hardship extension for this Class D beer, wine, and liquor license.
Yes, based on materials, letter, and testimony from the attorney, I also vote to approve the request for transfer hardship extension of 90 days.
Based on your March 5th letter and your proffer today, I also vote to approve this transfer hardship extension of its Class D beer, wine, and liquor license for 90 days.
Ms. Russell?
No exhibits for the record.
Thank you.
Jewel Box, 419 East Baltimore Street, Class BD7 beer, wine, and liquor license, and Class AE adult entertainment license. Request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article 12-1705B. Please come forward.
For the record, Melvin J. Kudensky representing the applicant in this case. There's another case where the prior owner, been here for a long time, now there needs some improvements, some upgrades before the inspectors from the city will sign off. They're very close, but they'll probably need, as indicated, another 30 to 40 days to finish it up so they can transfer it.
So you're asking for 90-day hardship extension?
That's correct.
90 days?
90 days.
Okay. Commissioners have any questions?
No questions.
No questions.
All right, Mr. Kudensky, then on the basis of your written request of April 15 and your proffer this morning, I vote to approve a 90-day transfer hardship extension for this BG7 license, and also for the adult entertainment license.
Yes, based on materials and letter and testimony from the attorney, I also vote to approve the request for transfer hardship extension of 90 days for BD7 beer, wine, and liquor license and a Class AE adult entertainment license.
Based on your April 15th letter and your proffer made today, I also vote to approve this transfer hardship extension of this Class BD7 beer, wine, and liquor license and the Class AE adult entertainment license for 90 days.
Ms. Russell?
No exhibits for the record.
All right, thank you. Good luck, sir.
Thank you.
The Manor, 924 North Charles Street, Class B beer, wine, and liquor license. Request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article 12-1705B. Please come forward.
For the record, Melvin J. Kudensky representing the applicants. This was a case where the problem, there was a comedy of errors when they first got started into the thing. There was two different groups that were doing the settlements and so forth, and they, through the end, they ran out of, didn't realize they didn't have the documents as Mr. Ferguson, they didn't have the transfer authorization, affidavit of compliance, and a bill of sale. Also, they had to get some issues straightened up with the taxing authorities, and they're finally pretty much getting close to having that done, but they'll need an additional 90 days.
Okay. Commissioners have any questions?
No questions.
No questions.
All right, thank you. On the basis of your written request of April 11, 2024, and your proffer this morning, I vote to approve a 90-day transfer hardship extension for this Class B beer, wine, and liquor license.
Based on material, letter, and testimony provided today, I also vote to approve the request for transfer hardship extension of 90 days.
Based on your April 11th letter and your proffer made today, I also vote to approve this transfer hardship extension of this Class B beer, wine, and liquor license for 90 days.
Ms. Russell?
No exhibits for the record.
All right, thank you, Mr. Kudensky.
Thank you.
Thank you.
Moving into the violation docket, Dream at Legacy Bar and Bistro, 10 South Calvert Street, Class B, beer, wine, and liquor license. Violation of Rule 3.12, general welfare, smoking on premises. Violation of Rule 3.09B, restroom facilities and health regulations. Compliance with state and city health department laws, rules, and regulations. Violation of Rule 4.20, little b, little I, Class B licensees, functional kitchen, sufficient food to fill orders. Violation of Rule 4.20, little b, 2 little I, Class B licensees, functional kitchen, fully functioning kitchen. And finally, violation of Rule 4.20, 20 little b 3 little I Class B licensees, functional kitchen, invoices of food purchase invoices. Please come forward.
For the record, Melvin J. Kudensky representing the applicants and the licensees.
Good morning. With those who are to your right and on my right, please raise your right hands, please.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Okay, if any of you speak, please step up to the mic and give us your name first, and if you need to, for the reporter, give us the spelling of your name so that he can get that down. Admissions or denials, Mr. Kudensky?
Don't deny the statements and what they found, but I do have some arguments with regarding whether there are violations of the particular rules.
Which ones?
The rule would be general welfare to the community based on, as I read it, there was no community problem in there. They had a problem with some smoking in there. I don't contest the violation with regard to the health department. And lastly, I think that violation of the rule 4.06, it is just the restaurant portion. It is the same rule. You just have subsections. So if you're not operating a kitchen, all the rest of the things wouldn't be there anyhow. So, I think it's a little bit of overkill having, 1, 2, 3, 4, because the first one was you weren't operating as a kitchen, you wouldn't have any of the rest of that stuff to start with.
Is that 4.2 or 4.06?
4.2, I think, I'm sorry.
Okay. Well, let's take them one at a time. So you are contesting that the facts don't suit the charge under 3.12?
General welfare, that's correct.
Okay, and it's your contention that the smoking is not a violation of, on the premises, not a violation of general welfare?
Correct, because there was no indication there's any threat or any inconvenience to the community. Now, it might be a health violation, I understand that, but not the other part.
So if they commit a health violation, that doesn't violate our general welfare?
I wouldn't think so, because it's a specific, one is not the same as the other, one is very specific. Most of the general welfare has to do with the community more than anything else, people outside the community, because that's the reason the rule was there. If it violates your rules, but it's not violating your rules, we're on the health department, which then you're bootstrapping all the way through. So that's my argument on that.
Sounds like that's similar to the arguments you're making on the other. You just believe that it's overcharged, is that correct?
Yeah, and because it's the same rule. If you look at it's the same rule, then you got 1I, 2I, 3. But if the first one is there, then you violated the rule, and that's it. So then after you, I don't know if you like my arguments or not. I got to make them, though, I think.
I don't have any objection to you making the arguments. I don't necessarily agree with you because I think there's probably plenty of indictments that charge every line of the statute. But in any event.
If you find guilty of one, the rest of them don't come through. I mean, you know what I'm saying? And you can over-indict, which I'm not going to argue that point.
Anyway, I think those are good arguments, and you're welcome to take them to the circuit court. I'm not going to dismiss these charges on the basis of it, but I appreciate the argument. Do you want to say anything about what happened on
Well,
this
they were,
occasion?
since that time, they've cleaned up, I don't know, with Inspector Chris Miles, have you been going back and saw what they've done since this violation?
Have you been sworn?
You want to swear him? Oh, I'm
Do
sorry.
you mind coming up?
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
I do. In reference to,
Yes, he indicated he had sent you some information as how they've straightened the issues up with regard to operating as a restaurant and so forth.
so I don't believe he sent me any information. We had a meeting. I sat down with both gentlemen and the deputy executive secretary. We called him in for a conference due to the fact that when I was there, I believe it was during this violation, the place was a nightclub. There was no indication that it was a restaurant. So I called them. I've worked with them in the past. They came in. They did say that they're going to attempt to, make it a bona fide restaurant. We went through, I believe, a week later with fire. Fire wanted to go because I think they were having a large party and they wanted to make sure that they're in compliance with the occupancy, which they were. And I did see someone in the kitchen cooking and providing food. But as far as verify, I mean, yes, the kitchen was open the last time I was there.
So just to be clear, Mr. Knessy, on behalf of your clients, you're conceding the facts that are in the report that I have?
So conceding what they say they saw, they saw.
Okay. So you're not requiring us to prove the facts?
No.
Okay. Okay. It does sound, and look, I understand. Which one of you is Mr. Hunt? Mr. Hunt, it may be that your initial business plan isn't working the way you wanted it to. You may have wanted a restaurant, and it doesn't seem like that is working. You might want to give some thought to obtaining a BD7 license so that you can operate based on the customers that you have. Mr. Knessy can talk to you about that. But this is not working for us. I don't want to see you back here all the time in violation. You've only had the license since 21, is that correct? Correct. And this is your third time for the board, so that's not good. So this needs to get straightened out. Commissioners have any questions?
No question.
I don't have any questions.
Do you have anything else, Mr. Knessy?
No, just the arguments that I made.
Okay. All right. On the basis then of the materials contained in the charging documents, which have been conceded by the licensees council, and any testimony received, I find a violation of Rule 3.12 General Welfare on March 22, 2024, a violation of Rule 3.09 Small b on March 22, 2024 with respect to the violation of the health regulations, a violation of Rule 4.20 Small b Small I on March 22, 2024, not having a functional kitchen, a violation of Rule 4.20 Small b Small double I on March 22, again for not having a fully functioning kitchen, a violation of Rule 4.20 Small b Small triple I for failure to provide food invoices on March 22, 2024. The last time that you were here, which was in January, you received a $200 fine for a general welfare violation. You can't keep doing this. So I'm going to impose $250 fines as to each of the violations, and I'll give you 30 days to pay. But I have to say, to keep this going, you're going to have a suspended license, so you've got to work something out. Commissioners?
Yes, Mr. Chair, based on materials and testimony provided today, I agree with the chair's findings of violation of Rule 3.12, general welfare, smoking on premises, March 22nd, 2024, with a fine of $250. Violation of Rule 3.09B, restroom facilities and health regulations, compliance with state and city health departments' laws and rules and regulations with a fine of $250. Violation of Rule 4.20B, small I, Class B license, functional kitchen, sufficient food to fill orders with a fine of $250 on March 22nd, 2024. Also, a violation of Rule 4.20B, double I, Class B license, functional kitchen, fully functioning kitchen, and a fine of $250 on March 22nd, 2024. Also, violation of Rule 4.20B, triple I, Class B license, functional kitchen, with invoices of food purchases on March the 22nd, 2024, with a $250 fine.
Based on the charging documents that were conceded by counsel, proffer made by counsel, and any testimony given today, I also vote that there was a violation of Rule 3.12 general welfare on March 22nd, 2024, violation of Rule 3.09B restroom facilities, but the health regulations part of that on March 22nd, 2024, the violation of the Rule 4.20B small I, functional kitchen, sufficient food to fill orders on March the 22nd, 2024. Also a violation of Rule 4.20 BII, functional kitchen, failing to have a fully functioning kitchen, and a violation of Rule 4.20 BIII, the functional kitchen portion, the ability to have invoices for food purchases. On each of those, I also agree that a $250 fine would be sufficient.
Ms. Russell?
Like call exhibits for the record, Board Exhibit 1, violation report, Inspector Tudhope, dated 3/22/24, exhibit number 2 through 15, photos.
All right, thank you, gentlemen. You should have a conversation with your counsel and try to,
Yeah, I'm going to talk to them on that.
okay.
Thank you.
Fielder's Tavern, 1184 through 86 Nanticoke Street, Class BD7 beer, wine, and liquor license. Violation of Rule 3.03 little a, records of alcoholic beverage purchases, and violation of Rule 4.08 little a, relations with wholesalers. Please come forward.
Good morning. You Mr. Warfield, sir?
Summers, Dante Summers.
I can't hear you.
Summers, Dante
Mr. Summers?
Yes.
Okay. Would you raise your right hand, please, and you as well?
Do you swear or affirm under the penalty of perjury that the answers that you give in the statements that you make will be the truth, the whole truth, and nothing but the truth?
I do, yeah.
Mr. Summers, what's your relationship to the licensee?
We run the business together.
Okay, so you've been charged with 2 violations of our failure to provide records of alcoholic beverage purchases and relations with wholesalers on January 29. Are you, do you want to admit those or deny those?
Well,
If you admit them, I'll give you a chance to explain, but
yeah, I admit those.
Okay. Go ahead, tell us what's going on.
Well, I closed one of the stores down that we had, and I just took the liquor that we had from the bar and put it on the what's the name, because I didn't know that we had to file a bulk transfer till the situation that came about. We never knew nothing about filing bulk transfer.
Do you have a lawyer? Do you have a lawyer?
Do I have a lawyer?
Yeah.
No,
I mean, for your business.
no, I don't.
I think you need to talk to one if you're going to do things like that. but-
When I'm talking about, no one really knew about the situation itself, but I understand what you're talking about for it, but yeah.
So, is this particular place on Nanticoke Street staying in business?
Yes.
Okay. And you were transferring,
Well, I was, but then I didn't do it after that point. Once he was letting me know about what happened, we removed everything from it, and I actually already have the relationship with my distributors.
okay. Do you want to tell us what you know?
Sure. I did go back to the establishment to do a routine inspection, and he did buy liquor from a distributor for February, March, and April after that.
So he just was unaware of what his requirements were?
Yes, sir.
Okay. Do you think it was an honest mistake?
Yes, sir. I did.
Okay. Commissioners have any?
I'm sorry, if you could identify yourself.
Agent Clark with the Baltimore City Liquor Board.
Yeah, I'm sorry. The commissioners have any questions?
No question.
No questions.
All right, Mr. Summers, based on your testimony and the agent's testimony, as well as the charging documents and your admissions, I find a violation of Rule 3.03A, records of alcoholic beverages on January 29, 2024, and a violation of Rule 4.08A, relations with wholesalers on January 29, 2024. You don't have any history of violations, although you've only had the license for about a year. But it sounds like it was an honest mistake. So I'd impose a $100 fine as to each of those 2 things and give you 30 days to pay.
Thank you.
Yes, based on material and testimony, I agree with the chair's findings. A violation of Rule 3.03A, records of alcoholic beverage purchased on January 29, 2024, with a fine of $100. Also, a violation of Rule 4.08A, relations with wholesalers on January 29, 2024, with a fine of $100.
Based on your testimony given today, I also agree that there was a violation of Rule 3.03A, records of alcoholic beverage purchases on January 29, 2024, and a violation of Rule 4.08A, relations with wholesalers on January 29, 2024, and I agree that the nominal fee of $100 per violation is sufficient.
Ms. Russell?
I'd like to call exhibits for the record. Board Exhibit 1, violation report, Agent Clark dated 1/29/24, and exhibit number 2, service request report dated 1/29/24.
All right, thank you. Thank you, Mr. Summers. Good luck.
Quick Mart, 6656 Bel Air Road, Class BD7 beer, wine, and liquor license. Violation of Rule 4.20 little c double I, prohibited activities by license type, open and operating tavern at all times. Violation of Rule 3.09 little a, restroom facilities and health regulations, shall provide restroom facilities for all patrons. And then finally, violation of Rule 3.09B, restroom facilities and health regulations, compliance with state and city health department laws, rules, and regulations. Please come forward.
Good morning. Stephen W. Fogelman on behalf of the licensee who's standing to my right, and this is a denial.
Okay. Would those who have not previously raise your right hands, please?
You raise your right hand. And you as well. Yes, ma'am. If you could. Do you swear or affirm under the penalty of perjury that the answers that you give in the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, inspectors, who wants to step up? Identify yourself first for the record.
Good morning. I'm on 313. I went to do an inspection.
What, your name?
Oh, I'm sorry. Regina Brown, Inspector Regina Brown, Baltimore City Liquor Board.
Thank you.
I did go to do an inspection prior to 313, which was 26. And I had a verbal conversation with the employees in the store, and I advised them to open your sinks, and you need to put stools out because they had like a lottery table. So I said, well, people can't sit and drink if they wanted to have a drink. So when I went back on 313, I violated them. They didn't have the sinks filled, and then the bathroom is behind a locked door where patrons can't go in. They would have to allow people to go back. But if you go in, it's a table where they keep all of their like money, security cameras. So a patron would have to walk past the desk to get into their restroom. But the restrooms aren't open to the public.
Okay. Did you have anything to add, Inspector? And your name first.
Inspector Zain Nazir, Baltimore City Liquor Board. I went and conducted a routine here about 2 weeks ago. The obstructed table was gone, the lottery table. The bathroom is still of concern because it's behind the locked register doors. But that's about it.
Okay, do you have questions for the inspectors?
you.
All right, do you want to put on testimony?
I'll make some argument at this point if you'll allow me to proffer some
Go ahead.
basics. I want to talk first about 309A. 309A says that this licensee shall provide on the licensed premises adequate, sanitary, and fully functioning restroom facilities for all patrons. It does not say that the bathrooms have to be open to the public. It is not a health department regulation. When I go to Popeyes, I got to get a key to use the bathroom. Some of my clients in this city have people who walk in off the street high on drugs and go into the bathroom and sometimes don't emerge for a half an hour and the door is locked. So I would submit to you that nowhere does it say that I have to have an unlocked bathroom. There's no testimony here that somehow these facilities were inadequate, unsanitary, or non-functioning. Now, in this case, there was a door to get to the bathroom. That door, they tried to leave it open, cracked. But once in a while, somebody would come through there, and that door automatically locked. To ameliorate the situation, they've put a doorstop in. Just a simple doorstop so that door to get to the bathroom won't lock. But I guess my point here is, and inspectors do a great job here, but 309A doesn't say what it needs to say to licensees in order to keep them compliant. So as far as 309A
Let me ask the
goes,
inspector a question.
well, there's no testimony here. I mean, their case is closed.
I just want to.
All right.
I just have a question.
You got it.
So you probably would agree that it is not, that a restaurant or any other licensee can have a key to give to a patron to go to the bathroom. Do you agree?
Yes.
But the problem here was that there was a door that was blocking it? Is that why you violated them?
The door is locked, so when I come in, even if I wanted to use that restroom, she have to come, stop what she doing, come around and open the door for me.
Okay.
So both times when I went, the door was locked.
And that was the problem?
Yes, that's the problem.
Okay.
So once again, Rule 3.09A says nothing about the bathroom door must
It has-
be open.
But the bathroom has to be accessible, though, right?
Right, and accessible upon request, and it only says to all patrons. It doesn't say to the public, thank the Lord, okay? It just says patrons. And look, it's more of a business decision in the sense that if my job is serving drinks, it's going to be a pain for me to have to give you a key every time you want to use the bathroom. And we're not serving, it's not Kmart. So, but again, it's not against the law to have a locked door in front of the bathroom or to buzz somebody into the bathroom. This isn't a tavern type operation rule. This is simply a bathroom for patrons, and nowhere does it say unlocked.
Okay. Commissioners have any questions?
And let me just, if I may, just continue on the other ones. Secondarily, 309B says all applicable state and city health department laws, rules, and regulations have to be abided by. I've heard no testimony that there was any violation of a city or state health department regulation in this matter. And to wit, the 3-compartment sink, which they have installed, which is a requirement, which is laid out in law, was fully operational. It didn't have water in it at the time, but they serve beer out of plastic cups. I mean, these laws are from the 1934, many of them, even though some of them have been updated, many have not. So why do you need a 3-compartment sink if you're serving beer out of plastic cups? Seems like a waste of water to me. Nevertheless, there was no testimony that that is some kind of illegality on the part of the city health department. Finally, with respect to 4.20 little 2, the holder of a Class BD7 license shall grant all patrons access to a fully operating tavern portion of the licensed premises, wherever that may be on the premises, whenever the packaged goods area is open and operating. So let me go back to the good old days when people used to get in trouble for 4.20 violations for patent reasons, for obvious reasons. That is, you have a liquor store side, then you have the tavern side. The inspectors would say, hey, I want to go in the bar. And they say, sorry, bar's closed. And I'll never forget a case where they took photos once they got access to the bar area. And there was a calendar on the wall from 1968 suggesting that, this bar was not accessible, all right? And that's your purebred 4.20 violation. This is a small bar within the store. And then, we had a case in here a few months ago where the people had built like a brick wall up around the bar, and we made sure that corrective measures were taken based on Your Honor's ruling, Commissioner's rulings. This is already a bar that you can access. And there was some kind of a lottery table, some kind of display that was temporarily over there. But it's not like somebody said, sorry, bar's not open. No, you can't drink here. That's what the spirit of 4.20 is all about, because it gives a competitive advantage over A licensees when you have a 7-day liquor store and nobody's allowed to drink. But there's no testimony that someone was denied service. Just because, there was junk in the way, it to me is so much different than we're not serving you. So I make those arguments with respect, and I appreciate your.
Okay, thank you. Commissioners have any questions? No. Just a minute. Do you have any questions, Joe?
I don't.
Oh, and finally, subsequent inspection on April 13th, despite all my argument, they're filling up the sink, and they have a doorstop now. So it's pretty reasonably priced solution to any perceived problems.
No disrespect, Inspector, but I think we've got a complete record, so I'm going to go forward. On the basis then of the materials contained in the charging documents, the testimony received, and the arguments from counsel, I find a violation of Rule 4.20, small c, double I, on March 13, 2024. It appears to me that issue has been resolved to our satisfaction. The licensee has no prior history of violations. I'd impose a nominal fine of $100 for that. I find a violation of Rule 3.09, small a, restroom not being accessible. I think there was a problem with the way it was. Sounds like that's been resolved as well. And on the basis of her good record, I'd impose a $50 fine for that. With respect to Rule 3.09 small b, I dismiss that violation, and I would give her 30 days to make those payments.
Thank you.
Commissioners?
Yes, based on materials and testimony provided today, I agree with the chair's findings. A violation of Rule 4.20C II prohibited activities by license type on March 13, 2024. On violation number 2, violation of Rule 3.09A, restroom facilities and health regulations with a fine of $50. And on the third violation of Rule 3.09B, restroom facilities and health regulations being dismissed.
Based on the charging documents and proffer made by counsel and testimony given today, I also agree that there was a violation of Rule 4.20C II, prohibited acts by license type, open and operating tavern at all times on March 13, 2024, $100 fine, and violation of Rule 3.09A, restroom facilities and health regulations on March 13, 2024, a $50 fine, and I dismiss the last violation, 3.09B. Have you guys thought about converting to an A7?
No. No, I don't believe they have.
Okay.
Yeah, but I'll definitely discuss that with them.
Okay.
Thank you, though.
Ms. Russell?
I call exhibits for the record. Board Exhibit 1, violation report, Inspector Brown, dated 3/13/24. Exhibit number 2 through 9, photos. Exhibit number 10, inspection report dated 4/23/24.
Thank you, Your Honor and Commissioners, for the indulgence. I appreciate it.
Liquor Station, 6506 through 10, Hartford Road, Class A, beer, wine, and liquor license. Violation of Rule 4.05, prohibited hours. Please come forward.
Good afternoon. Good morning.
Good morning,
Mr. Chairman, members of the board. For the record, Gary Maslin on behalf of the licensee.
Is this going to be an admission or denial, Mr.
It
Maslin?
would be an admission.
Okay. Want to tell us
Explanation.
what was going on March 24?
Sure. My client operates a neighborhood packaged liquor store. One of his customers had come in, was engaging him in conversation, and he got distracted as a result of that. And he neglected to close the store timely. And unfortunately, a few seconds later, one of the agents came in, and there was a sale made at 12, I believe it was 12:08 a.m. Since that time, he has put up signs saying that all customers must be in line by 12:40. You have copies of those?
12:40?
11:40. I'm sorry, 11:40. 11:40.
Do you know how to? Okay. Oh, yes. So please raise your right hand. Inspector, have you been sworn? Yes. Okay.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth? And are you Mr. Sims?
Would you tell the chairman and the commissioners what you've done since then?
Okay, so I put a sign over there that everyone should be in line at 11:50.
That's a sign he posted.
Sir, can you get closer to the microphone,
Yeah,
please?
and speak up, please.
Yeah.
I put a sign at the front of my counter that everybody should be in line at 11:40.
11:50, this
My
says.
bad, 11:50.
You just have to stop having long conversations. Was this a woman you were talking to?
Yeah.
Just curious. Okay, good.
He was extremely distracted. But he was, even in the report, it says they were in the process of closing, if you read further down. So it wasn't like they were trying to stay open for an extended period of time. It was just an aberration.
Let me
But
just
his-
ask the inspector a question. Have you had any repeated problems with them about this?
I have been back at around 12, and they've been closed every time. And he said they were in the process of closing. They only closed once we had gone there and told them to close. So
I understand.
that's...
Okay. Anything further?
No, Your Honor.
All right. Commissioners?
No questions.
No questions.
Okay. On the basis then of the proffer from counsel, which included an admission of the violation and the testimony received, I find a violation of Rule 4.05 prohibited hours on March 24, 2024. licensee has no history of violations, and has had the license for almost a year and a half. I'd impose a $100 fine and give him 30 days to pay.
Yes, based on materials and testimony provided today, I also agree with the chair's findings, a violation of Rule 4.05, prohibited hours on March the 24th, 2024, with a fine of $100.
Based on the proffer made today by council, which includes admission, I also agree there was a violation of Rule 4.05, prohibited hours on March 24, 2024, and issue a $100 fine, 30 days to pay.
Ms. Russell?
Under Code Exhibits for the record, Board Exhibit 1, violation report, Inspector Tudhope, dated 3/24/24. Exhibit number 2, receipt, and 3, photo.
All right,
Thank
thank
you.
you,
Good luck.
gentlemen. Have
Thank
a
you.
wonderful day.
L&M Liquors, 1148 East North Avenue, Class A beer, wine, and liquor license. Violation of Rule 3.05A, alcohol awareness certification. Please come forward.
Do we have service on the licensee, Ms. Wurzberger?
We do.
Okay. Who wants to present the case?
Inspector Tudhope, Baltimore City Liquor Board. On 3/11/24, Inspector Tudhope arrived at 1148 East North Ave at the establishment known as L&M Liquors to do a routine inspection. Upon reviewing all their documents, I observed that their alcohol awareness was out of date, and it had been out of date since 4/7/23. I spoke to the licensee, Mr. Lee, and informed him he had 10 days to get up to date, or to email or phone me and tell me he had made an appointment to set up to get a alcohol awareness. I had not heard from him, and on 3/22/24, myself and Inspector Brown returned to do a follow-up inspection. When I got there, I made contact with Mr. Lee, and he stated he was going to call and make an appointment, but he hadn't gotten to it yet. I informed Mr. Lee that he would receive a violation and left the establishment without any further incident. Upon review of the license, I saw that Inspector Brown had issued him a warning on 12/2/23 for having an expired alcohol awareness license.
Okay. Commissioners have any questions?
No, I just want to state, I think he should be here, even though it was only the alcoholic awareness certification.
Anything from?
Yeah, no questions.
Okay. Thank you. On the basis then of the materials contained in the charging documents and the testimony received, I find a violation of Rule 3.05 small a on March 22, 2024. Licensee was given repeated warnings and failed to adhere to those warnings and has a frankly lousy record before the commission. I'd suspend his license for a period of 3 days beginning immediately and instruct you all to pick it up today. Commissioners?
Yes, was that 3 days, Mr. Chair?
Yes.
Okay. Based on materials and testimony provided today, I also agree with the chair's findings. A violation of Rule 3.05A, alcoholic awareness certification on March 22nd, 2024, with suspension of 3 days.
Based on the charging documents and the testimony given today, I also agree that there is a violation of Rule 3.05A, alcoholic awareness certification on March 22nd, 2024, and issue a 3-day suspension starting today.
Ms. Russell?
Like Code Exhibits for the record, Board Exhibit 1, violation report, Inspector Tudhope, dated 3/22/24.
Mr. Chair, can I just ask a question?
Sure.
Are you waiving the administrative? Okay, yes, thank you.
Ms. Wurzberger, is that our docket?
That is it. Yes, sir. There being no further business before this board, the board is in recess until Thursday, May 23rd, 2024, at 10:30 a.m. We are adjourned.
Thank you. Thank you to everybody. For those to whom it applies, happy Mother's Day. We'll see you next time. Go Orioles.